Okay, so we are looking at the scope of agent's authority. I've already explained to you what is meant by the word scope. We have already talked about that one and the types of agent. Now, if you are an agent, you are only supposed to perform acts that have been designated by your principal. If the act has not been designated by your principal, in other words, if your principal has not, it's not something your principal has asked you to do and you do that, you will be held responsible or liable for that. Remember when we were talking about the fact that agency is triangular, we said agency is the relationship between the principal and then the agent. So when you say agency, that is it. But the agent will go and act on behalf of the principal in respect of the third party. So there's a third party that the agent will go and act on behalf of the principal. Then we said the principal will be held accountable. In other words, the third party can sue the principal if the agent fails to perform his or her duty. Why? Because the agent is not acting on his own. He's acting on behalf of the principal. So it is the principal's legal position that will be affected. So what we are doing here is that we are looking at the scope of agent's authority. What it means that if you are an agent and you don't do what the principal has asked you to do, you go contrary to his instructions, then you yourself, you the agent, you'll be held liable. In other words, when I say liable, in other words, if the third party wants to sue for breach, then the third party can sue the agent if the agent did not act in accordance with his duties or obligations or responsibilities assigned him. So agents are only supposed to perform acts that have been assigned to them by the principal. Otherwise, they will be held accountable for it. So unless the principal, one, ratifies it. Unless the principal ratifies it. And later we shall learn about what is meant by the principal ratifying it. We shall learn about that when we come to ways by which agency may be created. We shall talk about agency may be created by ratification, and we will learn about what is meant by ratification. So if the principal, if the agent does something that he has not been given authority to perform and the principal ratifies it, put simply, the principal adopts it. In other words, the principal accepts that even though the agent didn't have authority or formal authority to act on his behalf, he acted, but he has agreed. Then it means that the principal has ratified it. When he ratifies it, then it is as if or as though he has given the agent authority to act on his behalf. He has given them what we call retrospective authority. Retrospective authority means that it is as if the time they entered into agency relationship, at that moment he agreed that he could do that. Even though he couldn't have done that, now that he has ratified it, that is the implication. So if you are talking about the scope of the agent's authority, then the agent authority may be either by actual authority. So you have what we call actual authority, and you have apparent, which is also called ostensible authority. We have actual authority, and I've put into bracket express or implied. So the actual authority can be express authority or it can be implied authority. And you know what is meant by express authority, oral or written. So we are going to look at the scope of agent authority under express authority. And express authority is the authority that the principal himself has set forth. He has given to the agent to act on his behalf. So he tells the agent, I want you to act on behalf in doing A, B, C. It can be oral or written. They may, in other words, they may enter into that agreement either orally or in written form. So that is the express authority. He sets it forth. But let us know that if a principal and agent enter into agency relationship, and what the agent is going to do is that he's going to enter a contract on behalf of the principal. And that contract is a specialty contract. Then what it means is that the agency itself should be entered into by deed. So they should, if the agent is going to enter into contract by deed, then the agency itself should be entered into by deed. In other words, if the agent, right after the agency had been created, he goes to a third party to enter into a contract. Remember when we were talking about specialty contracts, we learned that if you are going to sell or lease a property and it's going to take more than 3 years, then that contract must be entered into by deed. Where we said that it must be written, signed by both parties, and should be under seal. There should be a seal. There should be a third party to witness. So if the agent, right after the agency relationship has been created, he goes to enter into a contract with a third party, but that contract he's going to enter into a third party should be a specialty contract, then the agency itself should also be created by deed. In other words, if the agency is not created by deed, the agent cannot enter into contract under deed. That is as simple as that. And essential element of a valid contract, one of them we talk about formality, will now come to play. He didn't enter into the contract in the form he was supposed to have entered into. And therefore, if the agent cannot enter into contract by deed. So that is the express contract. The next one is implied authority. Implied authority. What is it? It's very simple. Now, there is actual authority or there is express authority to act on behalf of the principal. For example, the agent is supposed to convey goods from Cape Coast to Kumasi. That is what he's supposed to do. That is the express authority that has been given him. Now, as a result of this express authority that has been given to him, there are certain acts that the agent should perform before he can perform that express authority. For example, if he's going to convey goods from Cape Coast to Kumasi, certainly he cannot carry the goods on his head. If the principal doesn't have a car, he would have to go and get a car, an appropriate car, to cart the goods to Kumasi. So once he has express authority to convey the goods or to cart the goods from Cape Coast to Kumasi, it means he has implied authority to hire a car to enable him perform that express duty. So implied authority, that is all that it means. It is the agent's authority to carry out certain acts that will enable him or that will enable them to carry out an express duty. It's as simple as that. So that is the implied authority. That implied authority can be incidental or customary. When you say implied authority is incidental, then we are looking at that act that the agent should perform to enable him carry out the express authority. For example, he has to, if the principal even had a car and he picked the car he was going, there is no tie there. He has implied authority to get a tie, to fix it. if the tire had become flat, he has implied authority to see a vulcanizer to inflate the tire. The people cannot, and if he pays for that, the people, I didn't ask you to do that. No. Once he has that express authority to carry out that express authority, there is something he has done. And that is the implied authority, and that is what is called incidental authority. It can be customary, customary. If you talk about implied authority being customary, what it means is that, you see, every business, every profession has their practices. So if whatever the agent does is in line with the normal practice of that particular business, he will not be held accountable for that. If it is a normal practice, it's a normal practice to pay tax. What that particular business, whatever he did, is it a normal practice? If it's a normal practice and he does it, the principal cannot hold him responsible. He had implied authority to do that, even though the principal might have not said it. He has implied authority to do that. So that is for implied authority. The last one is apparent or ostensible authority. Very simple, straightforward. When you say apparent authority, or when you say ostensible authority, you see, there are certain times, there are some people who may not have authority to act on behalf of another person because the person has not expressly granted him that authority. But what happens is that by the action of the principal, but the right way to use that, by the action of the purported principal, because he was actually not a principal, but by his action, a third party, an innocent third party, was made to believe that another person has authority to act on his behalf. Because of his action. So the ostensible authority or the apparent authority is inferred from the actions of the principal. That made a third party to believe that somebody was acting on his behalf or somebody was his agent, when actually the person was not his agent. Let me give you a typical example. For example, if somebody was dead, somebody who had a piece of land, another person decided to sell that piece of land, and he was right there. He was right there when the negotiations were going on. He was right there. So it's like X has a piece of land, and then Y decided to sell that piece of land to Z. In the presence of X, while the negotiation, X is aware that the land belongs to Z is aware that the land belongs to X. While they were negotiating, he stood there, he kept quiet. Probably inside his head, he was saying something, but he never said it out. By his action, what was that action? Keeping quiet. He made Z to believe that this one had authority to act on his behalf. In that respect, in that case, if later he tells Z that Y was not his agent and that he did not give him that authority to sell the land, the law will not allow him to deny that Z was not his agent. Later, when you go to agency, ways by which agency may be created, which I'm talking about, agency being created by estoppel, and this is the root. Apparent, when there is apparent or ostensible authority, an agency will be created, and that agency that is created will be called estoppel. And what it means is that the principal now will not be allowed to deny that the party now considered as agent was not asked to represent him. Because of his actions, he made an innocent third party, Z, to believe that Y had authority to act on his behalf. And the action here is that right in his presence, he kept quiet. Please remember that here, this example doesn't mean that, you know, some people say that silence means consent. Others say silence means consent. It is not consent. It is not consent. It is consent. Silence means consent. What they mean is that if you keep quiet, it means you have agreed to what I'm saying. Somebody tells you, for example, you are in Accra, somebody writes a letter to you, and the person tells that I want to buy your house. Please, if I don't hear from you, it means you have agreed to sell your house to me. That is a lie. It doesn't have any basis in law. But what we are looking at here is that we said silence means no. We are looking at you were there yourself. You were there and you kept quiet. So by that action, by keeping quiet, you made a third party to believe that the other party was acting on your behalf. So that is what is meant by apparent or ostensible authority. This is where we draw the curtains down. We have talked about, in other videos, we started with agency, and we talked about the meaning of agency. Then we came to types of agents. Prior to that, we had talked about who an agent is. Then we talked about types of agents, where we talked about universal agent, general agent, and special agent. Then under special agent, we talked about a factor, a broker, a del agent, a solicitor, an auctioneer, estate agent, and also mentioned accountant, and so forth, and so on and so forth. Then, right after that, we came to the scope of agent authority. Then we said if we can have actual authority, that can be either expressed or implied. Then we have apparent or ostensible authority. Then we pick them under three headings, where we talk about express authority, we talk about implied authority. Then we said implied authority can be described as incidental, or it can also be described as customary. And we talk about what is meant by implied authority being incidental and implied authority being customary. Then we ended with the apparent or ostensible authority, which in our next video we'll be looking at ways by which agency may be created. Have a nice day. Bye-bye.